Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years, your son has been arrested for 9 separate offenses?
9?
Yes, ma'am.
Right, Jonah Johnson, 25 DCCR 1775. It's not going to take much for me today to lose my. I'm right on the verge. I am at my word limit.
Good morning, Your Honor.
Good morning.
I have one witness in this case. Your Honor.
Good morning. Are you Jonah Ray Johnson?
Yes, Mom.
And this is 25 DCCR 1775. Mr. Johnson is charged with aggravated assault with a deadly weapon. And Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case. Are you calling your client?
Yes, Your Honor.
Mr. Johnson, best you can, raise your right
Oh,
hand.
no, I'm sorry, Your Honor. I'm not. I'm calling my client's mom, Jacqueline Broussard.
Ms. Broussard? Mr. Johnson, if you'll just come around just to the side, right there on the corner. Ma'am, if you'll come right over here, please. Good morning. And would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may proceed.
The judge calls the case and asks the woman at the stand to state her name for the record. She hesitates, corrects herself, and gives it. The judge notes she has been through this process before. She confirms she is Jonah's mother. The judge reviews the original bond set in September, $150,000. He asks what went wrong. She explains there was a problem with the ankle monitor. They believed it was malfunctioning. Payments were late, but they stayed in contact with the bondsman and were told to come in. She admits they were behind, but insists they never disappeared. The court reads the bondsman's complaint: failure to pay GPS fees, lack of response to contact attempts, inability to locate the defendant, and concern that the bond was at risk. The judge asks if she disagrees. She answers firmly, yes. She insists the bond was never at risk. The judge asks where Jonah lives. She says he lives with her and her husband in Beaumont, for people live in the home. They have lived there for over 5 years. The judge asks if Jonah was working at the time. She says yes. He was working in a kitchen job and had been there for several months. Jonah is 18 years old and lives at home. The judge asks directly if Jonah is a flight risk. She answers without hesitation. No, the judge asks if she is worried about him running. She says no and explains she would never risk her money if she believed he would take off. The judge asks which bondsman she has spoken with. She names 2 and confirms the same bondsman from September is still handling the case. The judge prepares to ask about those conversations as the hearing continues.
Not really realistic that that the court would drop to 100,000 now.
Mhm.
Are you asking the court to reinstate I don't know if reinstate the correct word, but to go back to the $150,000?
Yes, sir. Yes, sir.
Is that something you think you could work with?
Yes, sir.
They probably want you to sign a contract for $15,000.
Yes, sir.
I think 10%
Yeah,
is the
yes, sir.
Would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
And what else would you like to tell the judge about the bond?
I like the one. We are ready prepared to make fun.
Have you seen the video in this case?
Yes, ma'am.
Okay.
I have talked to my son. Yes, yes, ma'am.
You've actually
And the-
seen it?
Yes, ma'am.
Okay.
The whole video.
Okay. Anything else?
The prosecutor says there are no further questions, then pauses. He adds that he intended to ask one more thing. He asks whether the witness has seen the video evidence. Then he turns directly to her. He asks if she is aware that her son has been arrested 9 times in the last 5 years. She reacts with disbelief and asks him to repeat the number, and he confirms it. 9 arrests, he begins listing them one by one. Evading arrest as a juvenile, unauthorized use of a motor vehicle as an adult, possession of a controlled substance, unlawful carrying of a firearm, failure to identify, another possession of a controlled substance, possession of marijuana, and 2 additional charges for carrying a weapon unlawfully. When he finishes, the courtroom is quiet. He asks her a final question. Was she aware of all of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where he got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay, any other questions of this witness?
No, Your Honor.
Thank you, ma'am. You can have a seat.
Thank you, ma'am.
Any other witnesses, Mr. Vasquez?
No, Your Honor.
Mr. Coleman?
Judge, one of the items of evidence that I planned on introducing was the video from the shootout. But it sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to.
Let's just quickly play it. I want to, I'm refreshing my memory by taking, well, first of all, I'm gonna take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case. And I guess it was the other
It was the
case that
co-defendant.
we had a bond hearing on. Is that
Yeah.
correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, that would have been January 13th of 2026. My notes include that there's a defense motion to reduce the bond. We argued, you heard evidence and testimony, and that you denied the motion back in January of this year.
The judge
this
leans
was-
forward and reminds the courtroom that this exact issue has already been argued. The same evidence, the same testimony. Back in January, the court heard all the AT that time. The AFRS had already been reviewed, and the bond had been set at $300,000 during that same bond hearing. The judge is firm. She has not forgotten. She has not overlooked anything. Her ruling then was clear. The motion was denied. She starts to move on. But the prosecutor isn't finished. He stands again and carefully chooses his words that the court is unwilling to reverse its ruling. He says, then at the very least, the court should reconsider whether the current bond amount is adequate under the circumstances. He insists the state is not trying to relitigate the entire case. Instead, he explains, they only wish to introduce a short piece of evidence, a 5-minute jail phone call. Nothing more. The audio, he says, has been subtitled for clarity. To ensure the court can clearly follow the conversation, he adds that if necessary, he is prepared to bring in a sponsoring witness to properly authenticate the recording, or he asks, will the defense be willing to stipulate? The answer comes fast. The defense objects immediately. The objection is simple and sharp. Relevance. The judge does not hesitate. She sides with the objection if the state wants this evidence considered. She says they will need to do it properly. She instructs the prosecutor to call his witness. The prosecutor nods. The state calls Captain Michael Ponder. The courtroom shifts as the captain approaches the stand. He is sworn in under oath. The judge asks him to state his full name for the record. He does. She asks about his role. Captain Ponder explains that he serves as a custodian of records for the Jefferson County Correction Facility. He confirms that part of his responsibility includes overseeing and maintaining the jail's recording systems. The prosecutor walks him through the foundation. I ask the recording system capable of making accurate recordings? Yes. Does each inmate receive a unique identifying number? Yes. Is that number used to track and verify? Outgoing phone calls from the jail? Again, yes. With each answer, the room grows quieter. The legal groundwork is being carefully laid. Everyone understands what this means. The call can be traced. The voice can be identified. The evidence, if allowed, will speak for itself. The judge watches closely, and no interruptions and no expressions. Just listening be by the time the questioning pauses. The tension is unmistakable. Whatever comes next will either justify reopening the issue or confirm that the courts Earlier decision was right all along, and the room is bracing for which way it will fall.
I think, I mean, it's technically a new hearing.
Okay, I'll do one. Okay.
One's fine.
All right, you recognize this USB drive?
Yes,
How do you recognize it?
because I listened to it this morning.
And are these your initials in today's date that's on this USB drive?
Yes, sir.
I'm marking it as state exhibit number 1. You listened to it. Do you have any doubt that it's a fair and accurate copy of a jail phone call or recording of a telephone call made by an inmate, this inmate, from the Jefferson County Jail?
No, sir, no doubt.
All right, Judge, state off state.
Mr. Vasquez?
Good morning.
Yes, sir.
How long is this video?
This is
the
an audio.
recording,
It's
I'm sorry, the audio.
It's about a 5-minute excerpt from a 14-minute and 20 some odd second phone call.
Well, so it's been altered.
It's been included, yes.
Object to the alteration, Your Honor.
Judge, what's on here is the original 14-minute long video as well as the shortened 5-minute video with the subtitles added. So the original's on here.
Okay.
And by the way, I gave it to Mr. Vasquez yesterday, and he's had a chance to preview it.
States one, with both, will be admitted.
Permission to post, Judge?
Yes.
Judge, can I finish my objection?
Sure.
There's a object to the alteration, and then there's a transcription. I object to that as hearsay. Where you're give
The subtitles.
the subtitles of what you think they're saying.
Do you disagree that the subtitles are correct with what you hear?
I don't know, Your Honor. I just object to it being hearsay.
Oh,
How is it hearsay?
The subtitles are on it to what it's someone has written in what they've transcribed the conversation to be. I object to that as hearsay.
Mr. Coleman?
Judge, if the audio is not hearsay, which is a statement made by a party opponent, then the subtitles are therefore not hearsay. Judge, it's
I
just-
obviously will be able to listen myself and your objection's overruled. It's admitted.
permission to publish it.
Yes, and that's both the excerpt as well as the entire. And thank you, Captain Ponder.
Yes, sir.
Maybe reported or monitored.
that was a trick so good. Hey, this. Anyway, you gotta do at least one. Yeah, I mean, I just. If you go down that trip, he gonna put it up for college for five. Yeah. And they know it's his whole point. So, that's if my little folks go to ask question about, you want to leave your sentencing to the judge? And I said, hell nah. Take my shit to trial. I said, they're going out my bus for discovery. I seen all my evidence and shit. That shit bullshit, bro. Let me take this to trial, bro. They gonna drop the charge. So shot to take the charge. Ooh, my lawyer's good. Now he looking at the paperwork and shit like, oh, you good? You feel? You give him time. Like, I know it's gonna take time. Because everything that's going on right now, they ain't making it no better. My shit, but like I say, they come, even if they come like this, 5-year cap, they gonna say they off probation with a 5-year cap. I take that. I want to be careful. I want it 5 years. But if they do, I put like 2.5 on that bitch. Oh, come on, for maybe you have some bank time. You see, I'm gonna have some bank time. Sorry, I got 5 months bank time right now. You mean that 5 months, bitch? Damn. But this was 5 months. Oh, 2 months I did, boy. This shit look like shit over. Very good point of the phone, because I think really kind of been flying by. It is what you do, and just want to flying by. Sure. This shit. Very vicious. So, man. Wow, this is I ain't a mother, but this is very big. Something. And cause they been around young niggas, be so hard to do it after out the way. But you know, push gonna come to shove, some shit gonna happen. Boom, you know. Yeah, cause like that was my first write up. Like bitch, I've been chilling, so I've been quiet, doing that to nobody. That there's just write up, got another write up, I got fighting write up, other fight or something. But I think they moved to this door. Shit. It was straight out to the top. So I put me on game day, so it's going down like shit. So I guess it was my first 10 minutes, so I was gonna carry up boom. I said it's coming out of lead and go back. There's gonna be a lot of niggas like this, I'm good. I'm like, hey, I can't back to this, right? So I'm like, we got oh, hey, they can get out this over. But you see this, you know, I ain't gonna figure the world like this. It can't be good. Maybe I also shit say give a nigga probation for worse shit like that. Good. This how I know you come out on top with probation for when you they just gave my other part of my free world project nigga had 3 robberies. Hey, gave nigga ISL for 3 months and 10-year probation. That's like that nigga you can't even believe. That's what I'm talking about. They gave ISL 3 months. He had 3 months ISL. He got 10 years probation. After he was already on probation for 10 years. But crazy, him and the dude that got us to fight with the court the same day. Yeah.
That's all I have on that, Judge. State has no further witnesses.
All right, anything else?
No, Your Honor.
Okay. So at this time, I am going to deny the motion for a bond reduction. And I guess, Mr. Coleman, depending on any future incidents, if the state wishes to file a motion to increase, I would look at that at the appropriate time.
We have contemplated that, Judge.
But Mr. Johnson, a condition still, if you make that $300,000 bond, is that you would be on house arrest. You would be required to wear a GPS monitoring device at all times. Part of the reason that I'm doing this is because it sounds like you were working, your parents have the issues. I've looked at the bond, the affidavit for them to release surety. It's not just the GPS monitoring device. They obviously were having a hard time getting in touch with you for whatever reason. So I think that makes obviously one of the criteria under 17.15 for bail is that obviously you have to follow all of the rules and conditions of bond, which is with your bondsman as well. And so we will reset your case for an announcement, and Mr. Vasquez will visit with Mr. Coleman, get any offers in your case, and we'll either take a plea if you wish to take a plea at the next court date, or if you don't, we'll do a rejection and get your case set for trial. All right, you can go back with the bailiff.